Further hearing in the matter of the king on the application of Finch of Department of Legal Action Group against Surrey County Council and others.
Good morning. Lords, my lady, I've got another 30 minutes to run. Mr. Mouls has kindly said I can steal a few of his minutes if I need them. I hope I won't, but if I do, I may prevail on him.
Of course.
Can I start with dealing with what in our submission is the absence of any principled test to determine what indirect effects may be within the scope of the directive and the regulations. The absence of any such formulation was noted by Mr. Justice Holgate in the Court of Appeal, in the first instance, at paragraph 111 of his judgment, CV 439, and also by the Irish Supreme Court in Kilkenny Cheese at paragraph 104, CV 1749. The gatekeeper submissions that were advanced by my learned friend Mr. Hon yesterday, she says, are sufficient to provide some sort of control on these matters. And in my respectful submission, they do nothing of the sort for a number of reasons, which I'll deal with in a second. They are merely an acknowledgement of the fact that the appellants are not able to advance any clear principled test for the application of the requirement to assess indirect effects. And she advanced three gatekeeping principles. One, I'll run 1 and 2 together. The effect had to be likely and significant. Well, if I may say so, those are the threshold requirements for undertaking environmental impact assessment, at least with Schedule 2. They tell you nothing about what is then to go into the environmental statement. They are merely the hurdle to overcome, deemed in the case of Annex 1, Schedule 1 projects, and they don't provide any tests. They don't tell you what then amounts to an indirect effect, what then amounts to direct or secondary effects.
Yes.
The third proposition she advanced as a gatekeeper test was the impossibility of carrying out the assessment. Well, that's not actually, strictly speaking, accurate, because the directive specifically requires you, when undertaking an assessment, to refer to any difficulties or lack of knowledge or problems with the methodology that you've had in carrying out the assessment. So you can't dodge an environmental statement simply because there are technical difficulties. You've got to explain what they are. And you'll find that, I'll just put it's in both the directive and the regulations. It's Annex 4 of the directive, paragraph 6, which is CV 1256. So that provides no solution to the issue of a principled approach, nor does it provide a limitation. It is simply a general requirement, and it doesn't allow you to avoid assessment in any event. So they're not a useful or defining tool, and they provide, in my respectful submission, no principled basis for determining what an indirect effect is and how there is to be any limitation, sensibly, on the broad scope which the appellant submissions advance.
But to say that an effect is likely, you have to be capable of forming a reasonable appreciation of its probability.
Yeah,
and if you don't have sufficient information, you cannot do that.
Well, it depends on the level of information, my lord, because, of course, if you look at paragraph 6, it's dealing not with absolutes, but with technical difficulties, lack of information. Of course, you may be able to assess to a certain extent.
Yeah, but that you have to get over the hurdle of being able to say that it's a likely effect.
Yeah, but
and sometimes you won't be able to say whether it's likely or not likely.
You may not, but you take a precautionary, a risk-based approach, and so if there is a risk that there'll be a likely effect, you include it. But these gatekeeper submissions apply in any event to the threshold question of should there be an environmental assessment in the first place. And you're not then necessarily looking at the whole range of specific effects, but you're asking the question, is this development likely to have significant environmental effects?
Isn't what's supposed to happen that so the developer puts in the environmental statement, we're not including an assessment of this particular potential effect because there's no way that we can measure it or determine what it is. Then there's a consultation exercise and someone responds to the consultation exercise saying, oh yes, look, there's this perfectly acceptable way that lots of people use It's published by this international organisation. You should ask them to use that. And then the council goes back to the developer and says, why don't you use this method, which is a generally accepted method of assessing that? And then they either do or don't. But isn't that how it's supposed to happen?
My lady, I agree, because of course environmental impact assessment, as your ladyship's just indicated, is a process. It starts with the environmental statement but doesn't end with the environmental statement.
Yeah, but if you knock out from the environmental statement any reference to this because it's not an indirect effect, then that iterative process can't take place.
Well, it can, because if the court looks at Mr. Justice Sullivan Blewett, which was endorsed by this court in Friends of the Earth, his judgment, which has been followed consistently, says, well, the mere fact that the environmental statement doesn't contain material or may have a defect or a hole in it doesn't make it an unlawful non-environmental statement, because the process allows consultees, including the public, to advance matters which they say ought to be in the environmental statement but which aren't. And that's in the paragraphs in Blewett which my Lord Sales, along with Lord Hodge, endorsed in Friends of the Earth. And it's therefore down to if others wish to raise it, they can raise it, and it's then a matter for the local authority whether they think it's compelling or whether they require further information, which they're entitled to require under the Environmental Information Regulations. Because, as Mr. Justice Sullivan said in Blewett, otherwise environmental statements would be drafted on a wholly defensive basis, and to expect a council of perfection is unrealistic, as this court endorsed. That is why environmental assessment is a process rather than simply the environmental statement. And you'll see this in Regulation 4 of the national regulations, and you'll also see it in the definition of environmental impact assessment in Article 1 of the directive, that it is a process. Mr. Justice Sullivan, as it were, in Blewett, was ahead of the statutory definitions. They were only introduced after the Blewett judgment. Because it was necessary to clarify, I think, in terms of the EIA process, that it was a process and it wasn't simply the environmental statement. So, my lady, I don't accept that once the environmental statement is in the public arena, that it prevents other points or other evidence being submitted. The duty of the authority is then to decide what to do with it. If it requires more information, it has power to do so, and it has to take account of all the information that has been submitted to it, whether or not it's in the environmental statement. I've criticised already the open-ended approach of the appellants as to what may or may not be an indirect effect. That criticism can be made also of the OEP's written intervention. I'm not going to go to it, but I'd ask the court just to review it, particularly paragraphs 41 and 42 at CV 334 to 336. Although the OEP, on the one hand, says that it would welcome greater certainty from this court in defining indirect effects, the OEP's own approach seems to have the reverse effect, but it's a matter for the court to judge reading that intervention. The issues of the extent of indirect effects have been considered by the Inner House of the Court of Session in Greenpeace and the Advocate General, CV 2133, which agreed with Mr. Justice Holgate's approach at paragraphs, this is the Court of Session's judgment 63 to 68, CV 2145 to 6. I'll come back to that in a moment. And also, as I mentioned yesterday, by the Irish Supreme Court in Kilkenny Cheese, which is at CV 1717. Can I ask the court to pick that up briefly, so I can at least highlight the sections I direct the court's attention to? The issue...
What was the page again?
It starts at CV 1717, my Lord. The issues can be seen essentially from paragraphs 3 and 7. The issues are agricultural emissions, that is to say, increased dairy production and emissions from cows in the dairy production used or may be used, which may be used for the cheese factory, which was the project seeking consent in that case. And the central issue is described in paragraph 7, whether in that case, the upstream consequences, i.e. the need to have milk production to support the very large cheese factory that was proposed, was an effect of the proposals. And you'll see how that's put on CV 1719. The court started to consider the issue of EIA in part 4 of its judgment. There's a single judgment from Mr. Justice Hogan on behalf of the Supreme Court. It starts at paragraph 43, part 4, challenge based on the EIA directive 1731 is the page reference. It begins by dealing with the legislation, the directive, and the evidence. And you'll see the court's findings as to what was decided at paragraphs 72 to 77, pages 1740 to 1742, and then ask the question, will the project strengthen the overall demand for milk? And that then takes the court into consideration of effects at 1742 to 1744. And what the court said is firstly to look at the definition of project at paragraph 81, and then at 82, apart from the special cases, and those are the connected project cases which I referred you to yesterday, including Edenderry. Apart from these special cases, there are cases where there's a clear, unbreakable interrelationship between the project itself and certain off-site activities, such that a causal relationship between the construction and the operation of the project and certain direct or indirect environmental consequences has been clearly established. Then goes on to consider the possible interpretations. Starting at 87, first possible interpretation, open-ended meaning, and deals with the cases of Edenderry and Kemper, which were, as I submitted yesterday, effectively overall project determinations. That is to say, for example, the peat bog case, where the peat was being used solely to supply the power station and was a dedicated source of power. Then comes on to consider Finch in the High Court at paragraph 93 and explains that case. And Mr. Justice Holgate's consideration of Abraham and Ecologistas, I dealt with very briefly yesterday, but it's dealt with in our case. And at paragraph 100, he agrees with those conclusions subject to one possible caveat, he says. And the one possible caveat is at the second half of paragraph 102 on page 1749, which is the Edenderry type of case, which in fact isn't a caveat at all, because properly analysed, of course, the Edenderry case is a case of, well, what is the extent of the project? It's not just the power station, it's the power station plus its fuel supply. So it's not a caveat at all, in my respectful submission, and Mr. Justice Hogan wasn't entirely sure that it was a caveat, but he was making it clear there's a special class of case represented by Edenderry, which is simply a case where the project has to be properly analysed and is wider than might at first glance appear. He also looks at the Greenpeace case in the Court of Session at paragraph 101. He is troubled, and I'll come back to this, by possible implications of this wide principled case, a wide unprincipled approach to indirect effects at 100. He says, if it's given a remorselessly literal and open-ended interpretation, there's no principled basis. And he then says, significant environmental effects from the consumption or use of the end product would, or at least might, have to be assessed. Would this mean, for example, carbon emissions from the use of articulated lorries for transport of the cheese, or in considering large quantities of plastic required to wrap the cheese? Does this also have to be identified and assessed, and the implications of that? And he said these are just representative examples of potential indirect environmental effects in this wider open-ended sense. And he then deals with choosing between the options, the first option being apparently that paragraph 82 stipulation, and he notes at 104 the lack of principled analysis by the applicant in that case, and I've already referred to that paragraph. And then at 1750, he says there's support from Article 5 and a description of the project. My learned friend Mr. Mills is going to take you in more detail to the directive, particularly Annex 4. Paragraph 107, he says the climate change effects of the he deals with the climate change effects of the project, yet the proper scope, he says, of the EIA directive should not be artificially expanded beyond this remit.
Where are you reading?
I'm sorry, my lord. I'm 107, 1750. I'm halfway through.
There. Whereabouts in the paragraph?
About 5 lines down.
Thanks very much.
The proper scope of the EIA directive should not be artificially expanded beyond this remit. In particular, it should not, so to speak, be conscripted into the general fight against climate change by being made to do the work of other legislative measures, such as in Ireland, the 2021 Act.
Can I just take you back to paragraph 102 on page
Yes, of course, my lord.
1749? The two particular cases that you've referred to, Edenderry and O'Grady,
Yeah.
are illustrations
Yes,
given
Yes.
by the court
indeed.
of particular cases where the significant indirect environmental effects are properly to be regarded as a consequence of the project. So they're
Indeed.
off-site, they are a consequence, they are indirect relevant effects because the connection is sufficiently strong.
Yeah. And because effectively the project requires them. Because in the case, taking the Edenderry case, the peat bogs and the peat from them was dedicated to the provision of fuel to the power station and had its own dedicated rail link. So the judge in that case, you've got it in the bundle, I think I gave you the reference yesterday, it was regarded as effectively being part of the project. So, as I said earlier, it's questionable whether these are examples of indirect effects so much as an expansive approach to the project.
But you can get to the same result by either route, can't you? You
Yeah,
can say either it's a very narrow project but wide indirect effects, or if you want to include it as an indirect effect but have a narrow reading of that, then you expand the nature of the project so that it's undoubtedly connected.
Yeah, but what we don't get is necessary assistance in those cases as to what an indirect effect is for the reasons I've indicated. But even if they're, for example, the peat bog case is to be considered an indirect effect, of course it's so closely connected, it is physically connected with a rail link, and there are it's a dedicated fuel for use in the power station, and that's dealt with at length in the judgment. And if I can just continue with just the last few bits from the judgment to draw the court's attention to. You'll see at 110, sorry, I'm skipping this because of lack of time, but 1751, from an economic level, any enhanced milk production in the state which follows in the years to come is likely not to be entirely independent of the operations of the factory. But beyond this, however, proof of causality such as would satisfy the requirements of the EIA in respect of direct or indirect significant effects remains elusive, contingent and speculative. So he is requiring a strong causal connection.
Well, that's where the distinction with this case seems to me so clearly to lie.
I appreciate that, my lord, and I'm going to deal with the issue of inevitability in a moment. Well, I'll deal with it now. Lord, what is inevitable in this case is that the raw material produced from the well will be used to produce a manufactured product, which is what is to be combusted, and the inevitability arises from the fact that the oil will be used for that manufacture. It is not the project which leads to it's not the project which causes the production of the material which will be combusted. That is a separate EIA project. As I drew the court's attention to yesterday, refining is its own EIA project, paragraph 1 of Schedule 1, Annex 1, as opposed to exploitation of resources, which is paragraph 14.
But as I understand it, you would accept that one doesn't exclude the other. The fact there may be a downstream EIA in relation to refining doesn't preclude.
It does. What it does indicate is it's further down. It's further away in terms of causation, in my respectful submission, because you simply cannot use the unrefined oil without it being manufactured into an end product. And the same could be said for the metal smelting in Annex 1 and the production of chemicals. Are you to look at the end products of those matters as well? And the difficulty is the directive focuses on the specific activity, and the specific activity which leads to the combustible material is the refined oil, which has to go through a process which is not something which is part of this development project and is dealt with by others in circumstances which can't be stipulated precisely.
I just imagine myself trying to explain to somebody who's not a lawyer, why the extraction of the oil doesn't cause the effects of combustion. And I said, oh, no, it's not the extraction of the oil that does that. It's actually when it gets refined into fuel oil and then it gets burnt. And so my interlocutor says, oh, well, I suppose perhaps not all the crude oil gets refined. Oh, yes, it does. It's inevitable. It all will be.
Well,
or maybe it doesn't all get burnt. Oh, no, it all does. It's inevitable. It will be. Oh, but yet it's not causally linked, the two.
Well, it's not sufficiently causally linked, my lord.
Well, what more do you need,
Well, you can. Well,
except an unbreakable chain.
Well, my lord, it's not an unbreakable chain to the extent that you have to manufacture a product with it. That is to say, you have to manufacture.
You don't have to. We just know that inevitably it will happen.
No, but in order to achieve combustion, you have to, it has to go through that process. That process is a separate project.
So, if this was an application for planning permission for an oil refinery,
Yes.
would the climate change effects of combusting the refined oil be taken into account?
In my submission, the causal connection at that point would be such as that would be the case.
May I ask, if one postulate the illustration that my lord's putting to you, the oil is extracted.
Yes.
It's supplied to an existing refinery. Is planning permission required then, an EIA by that refinery?
No, but that refinery would have had to have had EIA when it was constructed.
Originally.
Yes.
I mean, assuming it's within the EU or the UK. I mean, it may not be. It may be somewhere else in the world. Crude may be shipped.
That's when you get into difficulties in terms of speculation with regard to the future process, and that
But you
itself.
can't I mean, there's no way you can rely on the fact that there will be a EIA assessment in respect of, or have been in respect of the refinery.
Well, if it
It has
was
any
in the,
relevance because the refinery could be anywhere in the world.
well, if it's in the UK or Europe, then the
Yes, I
answer
know,
is it
but
would be.
crude oil gets shipped around the world, as we know.
Well, that is the position. It requires an intermediate process, and the court's
Yes,
got to make.
that's the point. You rely.
That was the point in paragraph 122 of the environmental statement, which was then accepted by Dr. Solder in her review of
Indeed.
paragraph 5.15, which I understood her witness statement as saying she now accepted was wrong, and that point was not applicable to the consuming of the end product here. And she says, so it didn't have much weight in the council's decision-making process,
Well,
because now it seems to be accepted that was not a good point,
Well,
the point that was made in
well, the point that-
paragraph 122.
The point that was made in 121 and 122 that was off-site and out of the control of the applicant for planning permission.
No, that was 121.
Yeah.
122 was this point about you can see that there will be other controls later on, and so you don't have to worry about it here. Whereas
Well, in my respectful submission, the existence of that additional manufacturing process to produce an end product is sufficient to render it not an indirect effect of this project. I don't really think I can put it any other way. I mean, it is, of course, as a matter of fact, out of the control of the applicant, and it does require a manufacturing process. That is true of so much in Annex 1 of the directive.
Now, I know you've got more ground to cover, so
I do.
I think the primary concerns that are troubling my lady we've put to you.
Yes. Well, and I've made the submission.
Press on with your
Yes.
the ground you want to cover.
Yeah, I will leave further points on Abraham and Brussels Airport to Mr. Mills, if he'll forgive me. I draw your attention to Brussels Airport CV 1648 because there the European Court made it quite clear that regardless of the broad purpose of the directive, you still actually have to apply the concepts in the directive and the legislation as it stands. And you can't have an assessment if there isn't something which properly falls for assessment under the directive.
So which page is that? The particular page?
Brussels Airport is 1648, paragraphs 26 to 30 of the Court's judgment, 1662 to 3.
Thank you very much.
I'm not going to deal with the international cases. I've relied parasitically on the Annex to my learned friend's, Mr. Moore's submissions. I will say this. The Norwegian case Mr. Willers took you to yesterday does not assist for a number of reasons. He relies on the dissent. If you look at the dissent, the point is made that it should have been subject to strategic environmental assessment because the requirement for SEA is when something sets the framework for future development. And the dissent was focusing on whether the licenses granted in that case set the framework for future development. And the dissenting judgment actually says at 284 that EIA was no substitute for SEA. So it takes the matter nowhere. Similarly, local climate budgets, learned friend spent some time on that. Can I simply draw your Lordship's attention to the Goisa case, Mr. Justice Holgate, CV 12495 to 6, paragraphs 121 to 123, and they're non-mandatory, entirely a matter of discretion for the authority. However, what I do say is there is nonetheless a significant top-down sectoral review of climate change emissions under the climate change legislation. Again, there's not time to deal with that in detail. It's set out, it wasn't disputed in front of Mr. Justice Holgate. You'll see it in paragraphs 46 to 54 of his judgment, what the controls are, for example, on sectoral emissions, CV 425 to 428 in the judgment, and his conclusion at 105, page 438. And it's summarised in our written case at paragraphs 40 to 44, CV 197 to 9. So it is a case where the national legislation deals with the broader questions of such effects and seeks to control them. And you will have seen in two bits of the Norwegian case you were shown, paragraphs 241 and 246, if the court recalls, the majority judgment did refer to the fact that there might be a political solution to the effects of the oil licensing, and indeed that's how sectoral emissions are dealt with at the moment in this jurisdiction. I've mentioned the difficulties of assessment and the implications of assessment in the wider field. The submissions made by my learned friend have to hold good in the open-ended approach to indirect effects for all forms of environmental assessment. As she herself said, the language of the directive has to be applied consistently, and it applies to all projects. There is a very unhelpful point, and that is to say wrong and unhelpful, by Greenpeace about the German directive, but I'm not going to trouble you with that. The problem is the German directive actually says when you go beyond the bit quoted by Greenpeace in its intervention, it actually uses the German direct and indirect in Annex 4 to the German version of the directive, so it doesn't help them. And indeed, the French and Italian versions are wholly consistent, using the French and Italian for direct and indirect. So
it doesn't take anyone anywhere.
I don't think it does, and none of the European cases suggest anything in terms of the difference of language versions. Finally, then, the example of what do you do, for example, with a housing development with vehicles attached, particularly if it's a significant housing development. Do you have to assess the greenhouse gases from the transport that will inevitably be associated, or can be assessed to be associated with the housing development? Local authorities make assumptions all the time when granting planning permission as to how many vehicles should be permitted to park with a new housing development and the like. It's simply wrong, as my learned friend suggests, that you can't assess transport emissions. It's done all the time. Emissions of idling vehicles were considered in the environmental statement here. See Section 6 or such bits of it. as are set out in CV 470 and following, and the directive itself requires it. Annex 4, paragraph 4, requires the effects of the assessment on the air to be taken into account. Air quality is a frequent issue, particularly in air quality management zones. And paragraph 5C requires the emission of pollutants to be considered. So it's simply unrealistic and indeed incorrect from a learned friend to say, well, you can make a general assessment of greenhouse gases from 3 million tonnes odd in general terms, but you can't assess the transport emissions from vehicles being used for ordinary residential and commercial development. You can, and it's done all the time. So in my submission, there are significant consequences of taking the approach that the appellants take. I've made my point about the specific issue about greenhouse gases and the intervening refining project, which has to take place in an unknown location. There's nothing I can add to that. So far as the 4 grounds are concerned in the grounds of challenge, I've effectively dealt with those in passing. I dealt with materiality specifically yesterday. The section from the officer's report I'd meant to refer to yesterday and couldn't remember the reference, for which apologies, 493 to 501 in the bundle, where the officer's report addresses the balancing of the need for fossil fuels for the transition to net zero against climate change policy, and seeks to square the various competing considerations in terms of reaching a judgment on the planning merits of the application. That was not a taking account of benefits but not disbenefits, but a specific assessing of the policy context in which the application was made, that it would be producing fossil fuels, but that would be consistent with the government's energy policy. Lords, lady, unless there's anything else I can deal with, I've trespassed by a minute onto my learned friend's time.
Thank you very much, Mr. Roberts.
Thank you, Mills. I'm going to swap places with Mr. Mills. Just give me a moment.
Mr. Mills, do take a moment to
I'm grateful, thank you.
organise your papers. There's a lot of material, and sometimes the IT can be a little bit temperamental. So please, do take a few moments to make sure you are where you want to be.
Just my iPad, and I've got it. Thanks.
My Lords, my Lady, I'm going to focus my submissions principally on the statutory purpose and statutory language. I'll begin by looking at the Brussels Airport case, but then make my submissions with reference to the directive, hopefully picking up the points that have been concerning the court. So Brussels Airport is CV 1648. And as my learned friend Mr. Elvin explained, the question in this case was whether an authorisation to continue the operation of an airport was a project for the purposes of...
It's upside down.
The head note is upside down, the rest of it fortunately reverts to the correct orientation. The passage I'd like to refer the court to is the correct way up. It's on page 1661, beginning at paragraph 19, and this is where the court dealt with the question of whether that authorisation to continue operation of the airport was a project.
1661.
1661, yes, my lord, foot of the page, paragraph 19.
Thank you.
So the court began by looking at the definition of project in Article 1.2, which, as the court will recall, refers to works or physical interventions. It was put by the claimants in that case that there was a parallel with physical interventions in the landscape, but the court rejected that at paragraph 23. They rejected the analogy with extraction of mineral resources, and at 24 held that renewal of a licence to operate the airport in the absence of works or other interventions involving alterations to the physical aspects of the site couldn't be classed as a project. And in 25, they noted that, of course, EIA only applies to those projects that fall within the annexes. So the proposition I derive from this is that the directive isn't intended to cover activity generally or consumer behaviour. It is firmly directed at projects, which mean works and physical interventions. And the assessment is tied back to that. And as we saw when Mr. Elgin took the court to the recitals, there was a deliberate decision to integrate EIA into the development consenting procedures for projects, i.e. physical works, that require development consent. So the ambition of the directive is very much to require the assessment of the construction, operation of physical works and interventions. And I'll take the court now to the Advocate General in the same case, who makes the point even more clearly. It's on page 1656. In paragraph 29 of the opinion, this is Advocate General Mengozzi, and picking up...
Sorry, you have to give me the page again.
1656, my lord.
1656.
1656.
I find that an easier way of putting it. 1656.
1656.
Yes.
Last sentence of AG 29, the applicants in the main proceedings argued that renewal of the permit may have significant effects, and that was enough to require an assessment. That was then rejected by the Advocate General in paragraph 30, and effectively the Advocate General said that the mere fact that the activity will have an effect isn't what triggers the need for assessment. Assessment is very much tied to physical works and interventions and the assessment of those things.
Yes, but it does extend to subsequent activity carried on at that site.
Precisely, my lord, and I'll take you now to the annex to the directive to explain why that's so. In my submission, the annex to the directive, Annex 4, clearly shows that the assessment is focused on construction, including preparatory works, the existence of the project, and the operational phase of the project. And it doesn't extend beyond the operational phase of the project. And I'll take the court now to those provisions.
I'm not sure there's anything between you on that, but you'll come to that. But it's what we're concerned about is the indirect effects of that, or indeed the direct effects of that.
Indeed, where my submission is leading to is that Mr. Justice Hogan in the Kilkenny Cheese case was correct that the indirect effects have to be those which are intrinsic to constructing the existence of or the operation of the project. And when one looks at the matters that are required to be in an ES in Annex 4, it's clear that the operational phase encompasses the things that are effectively emitted from the site, and that the operational phase here involved the exercise of drilling and the noise and the vibration that would cause, the potential disruption to groundwater, the lorries moving to and from the site, taking the extracted oil. That was the operational phase, and that the senior president was correct to say that the project here that required to be assessed was the construction of the well site, the actual activity of extracting, removing from site, and the restoration, and that it's true that indirect effects of those activities have to be assessed. So take the example of drilling, deep drilling may disturb the groundwater. That may then affect indirectly a nearby a bogland habitat, because the water supply to the bogland is interfered with, and that dries up, indirectly affecting the plant species or the animals that live there. That is very much an indirect effect of the operational phase of the project. Once one goes beyond the actual drilling, the extraction activity, and the transporting off-site, the operational phase has ended, and something that may be causally linked, something that may be inevitable, is not inextricably linked to the operational phase. Perhaps I could take the court to the annex to show that is, in my submission, the correct interpretation. So the way into Annex 4...
May I just stop it so I understand where you're going? So your submission is very much allied to Mr. Justice Holgate, namely that this is an all or nothing question.
Well, my Lord, the question for the decision maker in each case is the effect one which is the effect on the environment the result of the construction, existence or operation of the project? And there may be room for judgment involved in that. I think I'm drawn to say on the facts of this case, it would not be rational to reach any other conclusion, and that's effectively what Mr. Justice Holgate said in his paragraph 126. He very much said in the circumstances of this case, as a matter of law, it's not an indirect effect. In my submission, that's effectively a rationality point.
Your submission is very much allied in this regard to Mr. Elvin.
It is, my Lord, yes. And although the senior president couched matters in terms of judgment, he agreed with Mr. Justice Holgate on the interpretation of the statute, and he didn't go so far as to say it would be rational on these facts to treat the downstream greenhouse gas emissions as indirect effects of the project.
So I'm confused now as to whether you're saying this is, as a matter of law, not an indirect effect, or whether you're saying it's a question for the evaluation of the local authority challengeable on Wednesbury grounds, and in fact it was an entirely rational decision.
And the only rationally possible decision.
Yeah.
It's the latter. My submission is it's a question of law for the court what the proper question is, and in my submission the proper question is the effect one that the construction, existence or operational phase of this project itself has on the environment? That's the question of law for the court. And then I say on these facts, it would not be rational to conclude that the downstream...
Well, it's when you get into rationality, then it's either right or wrong. It's not a question of whether it's rational or not, if it's a question of law.
In my submission, there is room for judgment in applying the statutory concept to the facts. If the court is minded to say it's either right or wrong, in this case, it would be wrong to treat this as an indirect effect because, in my submission, it is not intrinsically linked to the operational phase of this project.
Well, that seems to me a proposition of law, not a rational or irrational judgment.
It's certainly the construction of the statute and the question that must be asked is a proposition of law. If that admits
the way you put it, sorry. I mean, the way you put it strikes me as being clearly a proposition of law.
I'm content to accept it's a proposition of law. My concern to preserve an aspect of judgment is this, to put it bluntly. When an ES is prepared, there are frequently questions of primary fact which are contentious. So to take a common example, are there bats or badgers on this site which will be disturbed by the project? The ecological surveys show some badger droppings from 2 years ago. Are there badgers or bats? That very much is a primary question of fact which needs to be answered in order to judge whether this project will in fact have an effect. And my submission is that sort of question is very firmly a question of evaluative judgment for the planning officer, having taken expert consultation advice from internal ecologists and Natural England. Equally, there are scientific questions which may arise. For example, there may, going back to my groundwater example, drilling or extraction of gravel will affect groundwater flows. Will that in fact cause either a change in the pH of the drinking water downstream, or will it in fact dewater a protected habitat? That's a question hydrogeologists will differ on. It requires expert judgment in order to determine. So when I say there are questions of judgment in ascertaining whether there will be effects, those are the sorts of matters I say are very firmly within the purview of the decision maker, subject to rationality. if on the question, in terms of the question, is this putative effect, assuming the primary facts and the scientific judgments establish that it will eventuate, on that assumption, if the question is just, is it intrinsically linked to the operational phase, I'm content to accept that's a question of law for the court. So I hope that makes my position.
Flaring of gas that takes place during the extraction process because there is an excess of gas in the well or something of that kind would be, on your submission, an effect during the operational phase.
Undoubtedly, yes.
The burning of the oil that you're extracting somewhere else by somebody else is not.
Not unless you are in a Eden-Derry type situation and you decide that your project is larger than the extraction. So yes.
But on this analysis, on your submission, it won't be, because you're concerned here with an extraction process and operation, whereas the refinement will take place somewhere else. Consequently, the burning of that oil cannot be an indirect effect on your submission.
That's my submission, yes. And if I could go now to Annex 4 of the directive, the route to it is Article 5, which the court will find on page 1236. So 1236 Article 5, this deals with the information to be provided in an environmental impact assessment report. It has to, 5.1a, describe the project, 5.1b, describe the likely significant effects of the project, C is mitigation, D is alternatives that have been studied, E is the non-technical summary, and then F is the link into Annex 4. Annex 4 then tells you in more detail what your ES must contain.
1, 2, 3, 6.
So 1, 2, 3, 6. I'm grateful, my lord. So Annex 4 itself is found on 1255. It's headed Information for Environmental Impact Assessment Report. Paragraph 1 requires the report to contain a description of the project, in particular A, a description of the location of the project, B, a description of the physical characteristics of the whole project, including where relevant requisite demolition works and the land use requirements during the construction and operational phase. So there the focus is on preparing the site, constructing the physical works, and then operating those works. And then C, a description of the main characteristics of the operational phase of the project, in particular any production processes, for instance, energy demand and energy used. Well, that would be the Scope 2 emissions we've heard about. Nature and quantity of the materials and natural resources, including water, land, soil, and biodiversity used. So I emphasise the word used. That's what the operation of the project itself consumes. And then D, an estimate of the type and quantity of expected residues and emissions, such as water, air, soil, subsoil pollution, noise, vibration, light, heat, radiation, and quantities and types of waste produced during the construction and operation. So that's the emissions and residues from the operational phase of the project. It's not casting the net wider and bringing in all inevitable effects that, but for this project, would not occur. It is tied very closely.
But that's the description of the project. The effects of the project are a different question.
It is, and they're then in paragraph 5, my lord. Paragraph 5 describes the likely significant effects, and in my submission there's a parallel. Paragraph 5 effectively follows the steps of paragraph 1, looking at preparing the site, building the thing, it being there, its existence, and the operational phase. So in 5A at the foot of page 1255, describe the likely significant effects resulting from the construction and existence, and where relevant, demolition. B, the use of natural resources. C, the emissions of pollutants, noise, vibration, light, heat, radiation, creation of nuisances, disposal and recovery of waste. So again, it's the things immediately caused by operating the project. And incidentally, Annex 4, paragraph 5c, explains the decision in Squire, the chicken manure case. It explains why disposing of 2,000 tonnes of chicken manure each year was an indirect effect of a project to use land for raising 1.5 million chickens. The manure was waste produced during the operational phase of that project, and the directive expressly requires the ES to cover it. Then 5D is the risks to human health, cultural heritage, or the environment, for example, due to accidents and disasters. That's risks due to the existence of the project or the activity, its operation, bearing in mind that the directive is dealing with inherently risky installations such as pipelines, petroleum storage facilities, nuclear power stations. Then E is cumulative effects, and then we get 5F, the impact of the project on climate, for example, the nature and magnitude of greenhouse gases and the vulnerability of the project to climate change. In my submission, read in the context of paragraph 1 and the rest of paragraph 5, this is referring to climate impacts that result from the construction, existence and operation of the project itself. It's not creating a special category for climate that brings in third-party activities which aren't projects, which don't require development consent, and aren't the result of operating the project in hand. And as Mr. Elvin noted, the reference to climate in 5F also focuses on the vulnerability of the project to climate, so obviously things like flood risk posed to an inherently dangerous installation. And then finally, paragraph G is the technology and substances used. So again, the focus is on use, operation of the project. So my submission then is that the focus of Annex 4 is on effects caused or resulting from the construction, existence and operation of the project itself. And it's the effects of those things itself on the environment that are required to be assessed.
I'll look at the last paragraph too, just before 6. Because that elaborates, does it not, the nature of the likely significant effects that one is looking at?
It does. It says in the first sentence, and I agree this is a broad and expansive catalogue, look at all the things that directly, indirectly, cumulatively, etc., are affected. Going back to my example, the indirect effect, for example, of drilling is an effect on groundwater which has a knock-on effect on a habitat or a bird species. That's how these provisions in my submission should be read, consistently with Brussels focusing on physical works and interventions, consistently with the focus of the directive being to integrate these provisions into development consent for works, and consistently with the rest of Annex 4, which focuses on the operational phase. Those final words at the end of paragraph 5 aren't seeking to cast the net wider than the operational phase in my submission. And in my submission, that is consistent with the Kilkenny Cheese decision. If I could ask the court just to take that up, page 1717, it begins, and within it to go to 1748 at the foot of the page. And at the foot of the page, this is where Mr. Justice Hogan introduces his second interpretation of the provisions, the second possible interpretation being the indirect effects must be those which the development itself has on the environment. Effectively, that's my submission to this court. That's what the directive focuses on. And it's his paragraph 106 on page 1750, which in my submission is crucial in this decision. Mr. Justice Hogan considers that interpretation is correct. It's underscored, he says, by the language of Article 5. And also the provisions that I've taken the court to in Annex 4. and it's the final sentence I rely on. All of those provisions strongly suggest that the information to be supplied must be firmly tethered to the project itself, so the indirect significant effects to be assessed must be intrinsic to the construction and operation of the project.
May I just stop you for one moment? Because what I understand is said against you is, in the first sentence of paragraph 100, the alternative is put in a very broad way. It is said
Yes.
the alternative which the court is rejecting is that if Article 3.1 is given a remorselessly literal and open-ended interpretation, there is no principal basis by which the limits of any EIAR assessment could confidently be ascertained. Mm-hmm. Now, as I understand it, the case that's put against you here is that the alternative is not as broad as that. One is looking for a much closer causative connection, such as is found in the circumstances of this case, where it is inevitable, virtually inevitable, that it is going to be used for burning, and that will produce greenhouse gas emissions.
Indeed, in my submission, that's not an answer to my point. My point derives from the purpose and language of the directive itself, which is to focus on the physical works, not activity, see Brussels, and the references to operational phase. And in my submission, the purpose and language of the directive directs you to the projects, the effects of operating the project itself. And so, read in context, having regard to the purpose, that is the only correct construction in my submission. So,
as far as you draw support from the Irish case, though, if it were as narrow as you say, it's very hard to understand what paragraphs 108 to 110 are doing, when it seems to be thought relevant to look beyond the bounds of what was happening in the factory.
Well,
it's really because they're too speculative and elusive that it's considered not appropriate, outside what you take into account. But I mean, if it were taking as narrow a view as you say, you'd never get into the discussion in 108 to 110, would you?
Well, that's right, my lord, and I don't shy away from that. If one has regard to the purpose and the language of the statute, that is the end of the matter in my submission, and I don't rely on those.
On your submission, we would have to say that the reasoning here is wrong.
Well, in my submission, the reasoning effectively is paragraph 106, which is that the language of Article 5 and Annex 4 of the directive show that the effects have got to be tethered to the project and be intrinsic to the construction and operation of the project. That's the ratio in my submission, and the arguments from consequences may not be right, and they're not part of the ratio.
What is the effect of that? This whole discussion about where would they get the milk from, would there be an overall increased demand in milk, you say has to take place at this very early stage of deciding what has to be dealt with in the environmental statement.
Yes.
And as a matter of law, the environmental statement should not contain this kind of discussion which the court then engages in about whether this is significant or whatever. So that then is not something that is dealt with in the consultation and is not then a factor that the council should consider when deciding whether to grant planning permission to the cheese factory.
Well, that's correct. It would be open, obviously, for a consultee to say, well, I think these matters upstream or downstream are intrinsically linked to operating this project, and if that's put in a consultation, the local authority would have to decide whether, in fact, they were intrinsic to the operation of the project. But my lady's right, if they're not, and that's the conclusion, that they are not within the environmental impact assessment. And I say that's purely a function of the fact EIA is looking at projects, meaning physical works and interventions, and their construction, existence and operation, the operational phase of them. EIA is doing a very specific job. The recitals of the directive make clear it's integrating a process into a consenting procedure for physical works and interventions. not regulating activity upstream or downstream. Some upstream inputs would be relevant, because I took the court to Annex 4, and things like during the operation phase, paragraph 1C, materials used, natural resources consumed by the project, land, water, soil, etc., that they are brought in because they are effectively direct effects of operating a project. You need certain inputs. Where one's going one stage removed, then they are excluded.
Sorry, where are you referring to there?
So that was page 1255.
Sorry, just give me a minute. Yeah.
1255.
Yep.
Paragraph 1C. So a description of the main characteristics of the operational phase, production processes including energy demand, energy used, nature and quantity of materials and natural resources used. So we do look up, we're told to look upstream at the things that are required in order to operate the project.
That might be relevant to the Irish case, might it?
It might, my lord, yes.
But nobody's suggesting in the Irish case that effects on the wider milk production in Ireland are features of the project.
No. No.
So this is the description of the project itself here, but it's. You agree that its effects are a separate question?
So if the last sentence of 106 is correct, the Irish case could have been decided very shortly.
And I'm just wondering whether a test of inevitability as some sort of connecting factor between the project and downstream effects is authorised by the directive, because the directive, for instance, Article 5(1)(b), talks about a requirement to describe likely significant effects of the project. Sorry, that's page 1236.
Yes.
So throughout the directive, the emphasis seems to be on likely effects rather than inevitable effects. So I wonder whether it might be said that to try and, I don't know, carve out some test of inevitability and say, well, those are going to be effects of the project, that's a sufficient linkage, can be squared with the directive itself and what it does require.
Indeed, my lord, and the effects are always linked to the formulation of the project, and then in Annex 4 we see it's of constructing the existence of and the operational phase of the project. So in my submission, that's how the expression of the project should be construed in this context.
I mean, presumably the argument would have to go that if one is looking more widely than you say is correct to the effects of the project, you're really looking at likely effects. It's a probability test. And I think you would say that takes you back into the problems that the Irish Supreme Court identified about the first of the options that they identified in terms of interpretation.
Indeed, my lord, yes.
Okay.
And inevitability doesn't answer the question that I say is the correct question at the end of 106 of Kilkenny Cheese, which is this an effect which the operation of the project itself has on the environment? It's an effect that inevitably will occur, but is it an effect of operating an extraction well itself? In my submission, not. Because there is another Annex 1 project interposed, and because at the end of it, the activity which causes the release of greenhouse gas emissions is an activity outside the scope of the directive entirely, so the act of combustion in a motor engine. There was a rejection in the Brussels case that activity which has an environmental effect has to be assessed. If it's not a work or a physical intervention, it's out with the directive. And so, because one has here the interposing of another Annex 1 project and an activity of end users, they are not properly described as part of the operational phase of the project.
So I think your answer to the question I asked Mr. Elvin, namely would the effect on the climate of the use of petrol be an effect of an application for permission for an oil refinery? Your answer would be different from Mr. Elvin's.
It would be no.
Yeah.
Operating an oil refinery does not in itself result in the greenhouse gas emissions. And of course that oil refinery project, the ES for that, is governed by the same provisions in Annex 4, and we are looking at the effects of operating that refinery. Mindful of time, I'd like to just very briefly touch on Abrahams and then make a couple of points on Annex 1 to try and deal with the commercial purposes and whether that's a sort of oblique reference to end-use combustion. Abrahams, the decision is helpfully explained if one looks at the underlying legislation. If I could ask the court to go to page 1625, which sets out the provisions of the EIA directive. So that this was a project restructuring an existing military airport so it could be used by TNT, the freight company. So we've got an existing airport being restructured for freight use. The relevant project category is set out at paragraph 9 of Advocate General Cocott's opinion at the top of 1625.
So this is the Advocate General opinion, not the judgment, is that right?
It is. I'm going to the Advocate General just because she sets out the legislation, and then I'll go to the court. So top of the page, paragraph 9, it was an Annex 2 project in paragraph 12 of Annex 2, modification to a development project included in Annex 1. And then if the court would look on the previous page, 1624, the relevant Annex 1 project that was being modified was in paragraph 7, construction of, among other things, airports with a runway length of 2,100 metres. And so it's an Annex 2 project because you're modifying the existing Annex 1 project, the runway. The dispute is set out page 1627. Paragraph 17, it was effectively a noise complaint by the local residents, complaining of nighttime noise from the airport. Paragraph 18, they said the consent for the works was unlawful because there was no EIA. And in paragraph 19, the first instance court partly allowed their application, but paragraph 19, the Court of Appeal in Belgium rejected that, and it's the last sentence of 19 that is the crucial bit. What they said is that Annex 1 refers to the construction of an airport, Annex 2 applies to modifications, that is, modifications of constructions, and so effectively the Court of Appeal said the thing that has to be assessed is the construction work only, because that's what the project definitions in Annex 1 and 2 refer to. And that led to the question that we've seen at the top of page 1628, question 3 that was referred, which effectively was, does the EIA need to consider just the physical works, given that that's how the project is defined, or does it also have to consider their use? And the Advocate General answered that, paragraphs 29 onwards on page 1629. Paragraph 30, she said that the doubts of the referring court were based on the fact the increase in activity wasn't expressly mentioned in the directive, but she thought it was clear from the directive's provisions that it had to be taken into account. And importantly, in the last sentence of paragraph 31, that was because under the third indent of what was then Annex 3, now Annex 4, so that this is the annex telling you what goes in an ES, the estimate of effects includes, by type, quantity, expected residues and emissions resulting from the operation of the project. So in other words, it was clear from the text itself that operation is thoughts to be considered, even if the project is only defined in terms of construction works. And the court agreed with that, page 1645, at paragraphs 41 through to 46. So at 42, it refers to the broad purpose. 43 is the passage that the appellants rely particularly on. In my submission, all that was doing was rejecting the argument that Annex 1 and Annex 2, the relevant projects are couched in terms of physical works, and therefore that's all that has to be assessed. And the court goes on to agree that that's just inconsistent with the words of the directive, which tell you to look at operational effects. In my submission, that's all Abrahams is authority for. It says that an ES must consider the effects of constructing an operating project, and obviously I don't dissent from that. My Lady Rose and my Lord Sales asked whether greenhouse gases were considered. The short answer is no. Effectively here, the decision maker had excluded all operational effects, and that was the error of law. The court didn't need to and didn't grapple with what the operational effects might be. My submission is obviously correct that greenhouse gas emissions from aircraft using a runway is an effect of operating that project. Uncontroversial that they would need to be assessed.
But how far does the aircraft have to get from the airport before its emissions become too remote then? Or is it all the emissions of the whole flight of each aircraft from the airport?
Well, that's perhaps where there might be questions of judgment, how much of the flight and the movement is attributable to operating this airport. If the planes didn't take off from Heathrow, would they take off from Schiphol? Those are the sorts of questions of judgment. But in principle, if on the evidence it is concluded that this effect is attributable to operating this airport, then it has to be assessed. But those are questions in my submission of quantification and methodology rather than principle.
When you say it has to be assessed, what they have to do in the environmental statement is refer to it and either attempt to quantify it or explain why they can't quantify it, and then say whether or not it's likely or significant.
Indeed, and consider mitigating it as well.
Consider mitigating it. That's what the impact of including it as an indirect effect would be.
Exactly, my lady, yes.
You are running up against your deadline.
I am, my lord.
Are there particular points you'd like to emphasise? Because I'm conscious we've asked you a lot of questions.
I'm very grateful, my lord. If I could just very briefly go to Annex 1 and deal with the commercial purposes point very briefly. So Annex 1 is page 1245. So my submission is, firstly, there are plenty of projects referred to in Annex 1 which are apt to give rise to direct and indirect climate change greenhouse gas emissions. And so the climate provisions aren't rendered redundant by adopting the interpretation of the legislation I'm urging on the court. Examples are paragraph 2, thermal power stations and combustion installations. I emphasise the reference there to combustion. Paragraph 4, smelting works. Paragraph 7A, long-distance railways and airports. Paragraph 7B and C, motorways and other types of roads. The emissions of using them are clearly effects.
Then you get a slightly odd situation where if you're dealing with a particular kind of fuel, and the emissions, like electricity, all the emissions in producing the electricity occur in the production of it and not in the use of it. But with natural gas or crude oil, most of the emissions occur when you use it, not when you make it. So then you're if you don't count the emissions of use of it as an indirect effect, don't you get a sort of odd contrast between what a power station that's producing electricity or nuclear fuel has to say, and what a power station that's creating gas or coal or another power.
In my submission, not my lady, and the reason for that is that the target, the focus of the directive isn't on the emissions, it's on the project. And so one looks at what the construction, existence and operation of the particular project entails and the effects that that itself causes. And if a fuel is not used directly in operating the project, that answers the question. It's because the directive is tied to project as defined and as interpreted in Brussels Airport. If this were legislation seeking to deal, the Queensland
But
case,
if you burn gas to produce electricity in the power station, rather than supplying the gas, what emissions do you take into account in the power station project?
well, the power station is a project in its own right, and so thermal power stations and other combustion installations with a particular heat output, paragraph 2A of Annex 1. So that installation doing the combusting assesses its direct emissions. So that's catered for. The directive in Annex 1 refers also paragraphs 9 and 10 to waste installations for incineration and expressly refers to an act of burning. It refers in paragraph 19 to quarries and open cast mining without reference to commercial purposes. So coal, that's extracted as an Annex 1 paragraph 19 project. There's no reference to commercial purposes. If it's commercial purpose that does the magic and brings in the end user, that logic doesn't work with coal. In my submission, there are references in the annex to combustion, incineration and burning. If the legislature had intended that to be in focus in relation to extraction projects alone, where operating them doesn't itself cause the effect, it could and would have said so. It is the act of extracting only. I think I'm trespassing on my learned friend's reply. But
Does that essentially wrap up your oral submissions?
It does. If I could give the court one reference to one other case. It's the Queensland case, which is at CV 3229. Which is the 3229. That's the dam and the cotton ginning case, where a dam was constructed, and the question was whether effects of nutrient pollution on the barrier reef caused by farmers unrelated to the dam constructor carrying on cotton ginning upstream was an indirect effect. The answer was yes in that case, but if one looks at the legislation there was seeking to protect. It was directed.
You say the legislation is directed to is in a different form and directed to a different purpose.
It was focused on outcome, focused on protecting the environment, and the court at first instance expressly said it doesn't need to be intrinsically related to the project because the project isn't the focus of the legislation. In my submission here, purpose and language is different.
I think we've got your submission on this legislation. Thank you very much.
Thank you, my lord.
Mr. Dion, thank you. We've invaded your time a little bit in reply, but only by 5 or so minutes, so I hope that won't cause you a difficulty. If it does, make sure that you let me know, and I'm sure we can find that extra 5 minutes for you.
My lord, I'm very grateful indeed for that indication. Hopefully, that will not be necessary. I'll begin by addressing points made by Horse Hill Developments Limited, and then where there is some overlap now between their case and the Secretary of State. Then I'll look separately at the Brussels case, and then I'll end by looking at the Council's case heard yesterday. But just stepping back in relation to the Secretary of State's case and Horse Hill's case, it strikes the appellant that a lot of what my learned friend Mr. Elvin and Mr. Mooles's case hangs on is a series of fine distinctions that have an air of unreality about them. The distinction between the extraction just resulting in crude oil and the emissions actually being caused by someone else, foremost among them. Mr. Elvin also made the unreal distinction between high-level climate policy being a material consideration in planning terms, but not the actual extent of the downstream greenhouse gas emissions. That too is unreal, and I shall explain that in reference to climate policy in due course. The court has the appellant's points on inevitability. I don't repeat them, but just in response to Your Lordship, Lord Sale's question about the extent to which effects which are inevitable are something to which the directive has recourse. My answer to that question is yes. And you see that in the case law, in fact, the CJEU's decision in Spain versus the Commission. If we can just very briefly turn that up. At core volume page 1684, please. The court will recall that this was a case in which there was a track and then a parallel track had been built next to it, and the question was whether assessment was required of the parallel track. So on 1684, the court sees there at paragraph 59 at the very bottom what was said by the Commission against Spain. So that about 5 or 6 lines up from the bottom of that page, the Commission has in the present case provided to the requisite legal standard that the project in question falls within the scope. So that's not the question that we're dealing with here, that's a separate question, but this is the question. Moreover, it is indisputable that a project of this type is such as to create significant new nuisances, and even if only as a result of the adaptation of the railway line with a view to traffic. So just stepping back from that, that was the Commission essentially making the submission that there would inevitably be significant impacts as a result of that railway line.
But that's from the operation of the project itself, isn't it?
That is, I will get on to the point between operation and my Lord friend Mr. Moore's point about operation in due course. But just to finish the point in relation to what the CJEU decided, if your Lordship scroll up, please, call volume 1683 to paragraph 49. I took the court to where the Commission's submissions were most easily laid out. They are above 49 as well. But at paragraph 49, the court referred to a project of this kind, i.e. a kind where it had been said to them that there were inevitably or highly likely going to be significant adverse effects. And they say what they said in that paragraph. And I'll just invite the court to read it, please.
But again, those are effects of operation of the project itself, are they not?
Yes, correct. So if I can now turn to what the Secretary of State said about operation of the project itself. And in my submission, that set of distinctions...
Sorry, just on that.
Yes.
Even if it wasn't inevitable but was likely,
yes,
that would a likely effect of the project itself, that would be brought within the scope of EIA, wouldn't it?
Yes, but I think the point that was being made here was slightly different to that, if I may, my lord. It was not that it was just likely, it is that it was highly likely. It's that there was an order of magnitude more, and that's the point in this case.
So just on that.
Yes.
One doesn't need to get to highly likely before one is within the scope of EIA, within the terms of the directive. You just need likely, don't you?
That is so. But then the argument that the appellant makes is one step further, which is that when you're stepping away from what the project is and from whether EIA is required at all, and one is understanding the nature of what an indirect effect is, because that's what this court has been asked to do. What is an indirect effect? And the answer to that question, in at least one form, is if there is a highly likely effect which is going to result from the project inevitably, then that falls within what is an indirect effect if it is not a direct effect.
Highly likely or inevitable or likely on your submission. Do any of those do the job?
Inevitable does it as a matter of law, and that's what we rely on. And that was essentially the court's point to my learned friend for the Secretary of State.
Well, it doesn't likely do it as a matter of law.
Likely could do it as a matter of law, but that's not the way that the appellant has advanced the case and doesn't need to advance the case. Because the court would be aware that our case focuses on downstream emissions of fossil fuel development. And these greenhouse gas emissions, the downstream emissions of fossil fuel development, as a class of development, are accepted, well, are on any analysis, we say, the inevitable effect of the extraction of the fossil fuel, the extraction of the oil, the extraction of the gas.
But you'd be making the same submission if they were just the likely effect.
As a matter of law, inevitability matters because of the way it affects statutory construction.
But further to my Lord's question, the last sentence of paragraph 50, it uses the expression likely to have significant effects on the environment.
Yes, and so that's why...
And I mean, that's just reflecting the terms of the directive, which
Yes.
at various points talks about likely effects.
Yes.
So I can see that you've got a stronger case if you
Yes.
say inevitable effects.
Yes.
But the reason I'm pressing you on it
Yes.
is to test the logic of your submissions.
Yes.
Isn't the logic of your submissions that it would be sufficient if it was just likely effects?
No, and I think the reason for that is because of how we come to this as a matter of law. Your Lordship will recall, when I opened the case, I said that there were two routes by which this court could come to the determination that the downstream emissions were, as a matter of law, indirect effects. The first is as a matter of statutory construction, but and because the word is not elastic. That's the first point. The second route, and this is where the kind of test that my learned friend Mr. Moores was talking about, the second route is what we're essentially dealing with here. And that's where if this court decides that the meaning of the term indirect effect has some elasticity to it, then will the downstream greenhouse gas emissions fall within that as a matter of law? Answer given by the appellant, yes, because they are inevitable. That is different from the question which will then be asked at the EIA stage, which is, given that these are inevitable effects, are they likely to be significant? And as you see, in fact, from the Kilkenny case itself, the answer to that question can be different. So the Kilkenny case is actually an example of where an indirect effect, there an upstream greenhouse gas effect, was accepted by the court to be an indirect effect, and by the decision makers and by the developer, and I'll take the court to this momentarily. It was accepted to be an indirect effect, and it was included within the assessment. But the eventual result of that assessment was that even though it was an inevitable indirect effect, it would not likely be significant for a number of reasons.
So you say that the likeliness relates to the significance of the effect rather than the effect occurring.
Those two are the elastic words in the directive when you start to apply the assessment process. The inevitability of the impact, differently from likely or significant, goes in our case not to the next stage of how the effect is assessed, but this is a matter of statutory construction of what indirect effect means in the class of fossil fuel development. That's where inevitability is an operative aspect.
I find that quite difficult. It seems to me inevitability is simply the highest possible form of likelihood. I mean, I'm just looking at Article 1.1 of the directive, which refers, the directive applies to the assessment of the environmental effects of those public and private projects which are likely to have significant effects on the environment.
Yes.
So isn't the question of inevitability seems to me to go to the likelihood of the significant effects. The question of law is what is an effect of a project.
Yes.
So I don't really see that inevitability is linked to the question of what is an effect as a matter of law. I mean, once you say that the greenhouse gas emissions are capable in law of being effects, then of course you're into the realm of likelihood and significance and so on.
Yes, but the answer to that question, your Lordship's question about are they capable of being likely significant effects?
No, are they capable of being effects?
Forgive me, yes, that was a very unhelpful the response. Are they capable of being indirect effects?
Yes.
And we say as a matter of law, they are indirect effects because of the nature of fossil fuel development and its inevitable greenhouse gas impact.
Sorry, could you just say that?
It admits of only, it's the question of admitting of only one rational answer. Really, that's where inevitability arises.
But this isn't an answer to the submissions Mr. Moulds was making.
Yeah, I apologise. It is true that the discussion has moved on quite a lot from how I originally phrased it, which was Mr. Moulds' submissions.
Yes, he focuses in what is an effect for the purposes of the directive of a project.
Yes.
And that's a distinct question from likelihood and inevitability.
Yes, and what he does, and let me turn to address Mr. Moulds' submissions directly. He makes the distinction between the phases of a project, the construction, the operation, the decommission. And his submission is that the extent of the effects which are relevant to be assessed are the ones that happen at the operational stage, the operational phase, and that is essentially restricted to what is going on site.
Well, arising from what is going on on site.
Arising from what is going on site.
Yeah.
But that is simply unreal in my submission, because for minerals extraction, that entails this court averting its eyes from the 3 million tonnes of oil that are being extracted as part of the minerals operation, which requires separate permission, the actual extraction process, and are then being taken off-site and in order to be refined, in order to be combusted. So when one is dealing with what is the operational phase of a minerals development, the answer is not just the things that are happening on the site. The operational phase of a minerals development must be the oil that is coming out of the ground in certain volumes, indeed in sufficient volume to bring the project within Schedule 1 at all. It is the oil itself which is the project.
Well, extraction of the oil.
Yes, but the oil is the mineral, and that's the whole point of this focus. When one focuses on the fact that it's the extraction of the mineral which is the project that one is dealing with here, then it is not right in the appellant's submission to say what is the operational element is simply what's going on the wellhead in terms of the physical mining process.
Well, as I understand it, the case that's put against you is that it includes effects on the environment from that drilling process and the extraction of that quantity of material, whatever it is, because that may interfere with water courses, it may interfere with natural habitats and so forth. And all of those are properly taken into account as direct or indirect effects of the operational phase, but not the burning of the oil by somebody after a refinement process, which may be an unnecessary addition for his submission, but by somebody else off-site, which is not an element of the operation. That, as I understand it, is the case you have to meet.
Yes. My Lord, that's our ground too. which is an indirect effect, does not have to be encompassed within what the project is, i.e. the operation, in order for it to be an indirect effect. In fact, that is the point. The point is that to be an indirect effect, there will be a mediation between the operation and the effect. There will be intermediate steps. No one is suggesting that this is a direct effect of the operation. It is an indirect effect of the operation. And one cannot use those intervening steps as a way to define the indirect effect out of being one. Because the whole point of an effect being indirect is that there are these intervening steps. So one can't, for an indirect effect, look at just what is going on the well side. One has to look at also what happens after the various intervening stages. And in fact, an analogy can be made quite easily with what happens in housing developments and air quality. Because whatever the operational stages of a housing development, and however my learned friend would choose to define that, I cannot see how, in his analysis, the driving by residents of their cars backwards and forwards and the air quality impact that that causes falls within what he proposes to be the limits of an operational phase of the development. But those are effects that are assessed all the time as indirect effects.
Well, one of the cases concerns commercial development and employees coming to and from the development, and the emissions caused by that have to be taken account of. But doesn't that result from the operation of the commercial development? It's part of operating the office block.
Yes.
That people come to and from it.
Yes, and part of operating an oil extraction development is that the oil is extracted and then refined and then burnt. That is the whole commercial
I think the
process.
issue, isn't it, really? Is that part of the operation of the oil well?
It is an inevitable indirect effect of the operation. In the same way that the use of vehicles by residents or by employees is an indirect effect of the operation. The employees could walk, but they don't. The residents could walk, but they don't.
One way of, sorry to interrupt, but one way of looking at it, it's a possible way, which seems to be on at least one reading what the Irish Supreme Court was saying, is that generally speaking, you don't look at things happening off the site, as it were. They don't come within the compass of direct or indirect effects. Yes. But if the link is sufficiently strong, then you do take account of them. And on that reading, it may be relevant to say that it's inevitable consequence in order to bring it within the scope of of those effects that count. It doesn't require you to say that everything you can say is a likely off-site consequence is going to be within the scope of the relevant effects. So there is at least as I see it, some middle ground there.
My Lord, yes. What I would say with the greatest respect to the Irish Supreme Court is that it's just wrong as a matter of interpretation of the EIA directive that what happens off-site is not relevant to the environmental impacts. If I may take
just on Kilkenny.
Yes.
What do you say about Mr. Elvin's point that, in fact, the qualifications that they offer to the approach adopted by Ms. Justice Holgate, by reference to Edenderry, and I forget the name of the other case, are in fact reference to cases where there's an expansive view of what the nature of the project is?
I say that's wrong, and wrong in particular in relation to Edenderry. And the easiest and quickest way I can take that is by giving your lordship the reference to the OEP's analysis of the Edenderry case. That's at core volume 341, paragraph 61? Paragraph 56.1, yes, I've got 561, which is obviously not right. 56.1 of the OEP's case, where they make the point that Edenderry was not about the breadth of the project, but about the meaning of indirect effect. And just on that point about so closely connected, in the appellant's submission, just to recall in terms of timing in relation to the Kilkenny case, the court only had before it Mr. Justice Holgate's decision and the Greenpeace decision, which simply took Mr. Justice Holgate's approach without really analysing it. And the Supreme Court in the Irish case was obviously uncomfortable with Mr. Justice Holgate's approach of excluding greenhouse gas emissions from being indirect effects because of this caveat that was put on page CV 1749 at paragraph 102 in relation to the strong and unbreakable connection between the construction of the project itself and the off-site activities. So that's paragraph 102, CV 1749. And in my submission, the downstream greenhouse gas emissions of fossil fuel development fall firmly within that caveat. There is a strong and unbreakable connection, if one takes any realistic view of the situation, between the construction of the project itself and the off-site activities, because if the oil was not taken out of the ground, it would not be burned, and there would not be greenhouse gas emissions resulting from that burning. When pressed by the court, Mr. Elvin, in fact, responded that the emissions in this case are not sufficiently causally connected or linked because they don't have a manufacturing of a product associated with them. But in my submission, that is no answer. The nature of hydrocarbons makes the connection closer, not further away. There would be required to be some further manufacturing of a product. And I also note there, my lords and my lady, that that's a recognition that there is no change in the product via the refinement and then the burning process. The refinement stage doesn't change the extent of the greenhouse gas emissions impact that will be assessed under the EIA assessment regime. Two more points, if I may, in relation to the Kilkenny case. First, when my learned friend, Mr. Elvin, took the court to the facts, he glossed over what in my submission is an important paragraph. If the court can turn up, please call volume 1718. 1718 in the factual background of the Kilkenny case. My learned friend took the court to paragraphs 3 and paragraph 7, but could the court please alight on paragraph 5, which in my submission encapsulates what the court was dealing with. It's specifically the difficulty that is articulated is the reference to significant indirect effects and what is meant by significant indirect effects of the development in Article 3.1. And if the court turns on, please, to CV 1751, at paragraph 109, when the court is summing up the question before it. Sorry, 108, paragraph 108, CV 1751. The question that the court sums up 3 lines down. Well, in fact, can I just ask the court to read that paragraph? Because what we say is that clear the question was about significance, not about the meaning of an indirect effect.
Which paragraph, sorry?
So it's paragraph 108.
And what are you taking from that?
So the key point from that, my lord, is that what the court was grappling with was the question of whether these upstream emissions were a significant indirect effect, not whether they were an indirect effect at all. That was not the question before the court because, in fact, the environmental impact assessment assessed them. It accepted the upstream emissions were indirect effects, as did the inspector, as did the board. And the court can see that at core volume 1739, paragraph 68.
Sorry, I was reading paragraph 108 as referring to the board and the inspector, who had made very particular findings, which, if you took those at face value, would suggest that there was no effect from the cheese factory because there'd be a diversion of existing milk production. Isn't paragraph 109 the summation of where the court says that may be too narrow a view if you look at what's likely to happen in consequence of the economics of increasing demand for milk?
My Lord, that's not, in fact, in my submission, what was being said in that paragraph. And the reason that there was a focus on the question of diversion or on the question of offsetting was not because it was an issue whether there would be an indirect effect at all, but whether that effect would be a significant effect. And I can make that good by reference to the two paragraphs that I'm going to take the court to next about what the board and the inspector actually said.
But sorry, just on 108,
Yes.
the particular findings made by the board and the inspector was that the milk was going to be produced in any event.
Yes.
So that's no effect.
No, my Lord, I'm sorry, it's not.
All right, okay.
That's the reason that it is not a likely significant effect.
So the question of whether cows produce methane when they're growing milk, producing milk, that is the indirect effect. The issue about whether there's actually going to be more cows producing more methane is whether it's likely to be significant or not.
Correct. And this is exactly the same sort of argument that's made in relation to downstream emissions and the point that was made earlier on in these proceedings about substitution. It's not an answer to say, are you an indirect effect? To say, oh, well, the same impact might happen anyway. The question of whether something is an indirect effect of this development or not is different from whether that effect would be significant or not. This is the frack-free Rydale example. So the burning of the gas in the power plant at Knapton was an indirect effect of the gas being extracted. But was there any additionality? On that case, no, because the power plant was capped in what it could produce by way of permit.
Well, what's put against you in relation to that example is that the burning of gas during the operation of the plant or the project is an inevitable consequence of actually operating it. It's not a question of what you're going to do with what the product of the project is. It's a question of ensuring that you can actually operate the project in the first place.
My Lord, that's not right in relation to, certainly in relation to minerals projects, but in my submission it's not right generally, and that's for two reasons. The first is that, a bit like the Squire case, it would have been possible with the chicken manure that was produced for it simply to be stored in a large storage facility and spread within the confines of the development site in due course. That would have been effects all within the project. But the choice that was made was for the manure to be shipped off-site and to be spread on third-party fields as well as being spread within the development site. And in those circumstances, it was accepted that there was an indirect effect from the spreading of that manure. In the same way, for the Knapton example, the gas could have been flared on site. In a flare, the methane would have been emitted essentially as a direct emission via flaring as CO2. But what happened was, instead it was taken off-site, added to Napton and burnt there. And that was an indirect effect because of the intervening steps.
But in both cases, are they not indirect effects specifically of the project? So if one takes the Squire case, I think Mr. Moore's pointed us to paragraph 5C in Annex 4 to the directive, which is page 1255, that a description of the likely significant effects of the project on the environment resulting from various things must be included in the environmental statement. And C says the emission of pollutants, noise, vibration, light, heat and radiation, the creation of nuisances, and the disposal and recovery of waste. So in the Squire case, it was clear that there was going to be waste produced from all the chickens, and therefore the environmental impact assessment had to deal with how is that waste, which is a very direct product, to be dealt with, even and should take account of indirect effects that might have on other people's property.
My Lord, two things. First, it wasn't a very direct product. It was an indirect byproduct. The direct product of the poultry sheds was chickens for slaughter.
Right, but
the waste was a byproduct. Second,
okay. It was an inevitable product.
It was an inevitable product.
Yeah.
It was an inevitable byproduct of the project. And second, the planning permission which was sought was for the physical chicken sheds, for those 4 physical chicken sheds. There was no planning permission required or asked for the further step of taking the manure, using it as fertilizer, and spreading it on the field. It was not something for which planning permission was required. It wasn't in the description of the project. It wasn't essentially part of what the development was at all. But it was the inevitable byproduct, and so it was an inevitable indirect effect. The situation we have with greenhouse gas emissions and fossil fuel development is by yards clearer than that case. Because here, the description of the project is the extraction of the oil at a certain volume for commercial purposes. That is what requires planning permission. And that particular mineral is being extracted in order that the indirect effect can occur, i.e. the burning of the oil.
So you say the difference is that the project here is not simply building a factory using a drill, making a hole in the ground. It's actually the extraction of the oil.
Yes.
Whereas with the Squire, it was building the chicken sheds. You didn't have to have, or maybe not under this regulation, did you have to have, probably have to have a license for keeping that number of hens or whatever. But
it's one of the listed. I mean, it's in the annex, isn't it? So seeking permission for broiler chickens of more than a certain number requires permission requires an assessment.
And that's the second answer to my Lord's
so just also in relation to that, and the directive allows a member state to integrate environmental impact assessment into its ordinary processes for authorisation of development. So I think that what would happen in the Squire case was you need planning permission as a matter of our general law for the development to build the chicken sheds, and integrated into the process for whether you get planning permission is environmental impact assessment, and that satisfies EU law.
Yes. But obviously, and that's the second question to you, the second answer to your Lordship's question, obviously one has to have a project which requires assessment in order for the indirect effect to be an indirect effect under EIA. I mean, that's a statement of the obvious. That's the point that's made by the OEP and indeed the appellant in relation to the floodgates argument, or the concern that there's going to be too many projects that are brought within the purview of EIA if indirect effect is given the meaning not direct effect. And the answer to that is it has to be EIA development in the first place. This is Schedule 1 development, and Squire was also brought in the way that has been described. And then the question is, what is the indirect effect of that project? The appellant has never suggested that one. Well, I've made the point. I don't need to gloss it. I have a very firm eye on the time. There are.
Certainly, for my part, one of the matters I'd be grateful if you would cover at some point is the way that this is said by the respondents to be integrated into a much broader picture, and that issues about the operation of refineries, or subsequently the way fuel may be burned, are all matters which are dealt with at a different level. And were one to start to impose those sorts of considerations on the decision-making process with which we're concerned, it would become hopelessly unwieldy and indeed is completely impractical. And they introduce into that, I understand, the cross-border, the cross-boundary issues. Yes. And certainly those are questions which I don't think you've yet addressed, and for my part I would be grateful for assistance on.
My Lord, yes. So just on the fact that the refinery is also Schedule 1 development and may be subject to its own assessment, and so is in some ways some sort of intervening project. There are a number of answers to that. The first and most important one is that there is no new refinery requiring EIA on the cards here. We're dealing with oil that is going to go, on everybody's case, to existing refineries. So the fact that in a different circumstance a new refinery would have an EIA is nothing to the point.
But again, as I understand it, what is said against you is that the refineries that already exist will be operating within their own limits, which are set and regulated, and consequently it's not appropriate to be importing all those sorts of considerations into this analysis. So whether there's a new refinery or not, or whether or not carbon emissions downstream are ultimately a consequence of this particular project, is neither here nor there, because they're looked at in a different framework.
No party in this case suggests, unlike the Napton example, that refineries operate in a way to limit the extent of greenhouse gas emissions via permit, or in a kind of operational way that they are constrained by laws or regulations or permits that would mean that there would not be an additional greenhouse gas impact. Sorry, as there was a lot of negatives there. But essentially the point is this. There is no further point of restraint as to the extent of the greenhouse gas emissions that will be emitted that comes from the refining process. That's first. And second, we have no idea where this oil is going to be refined. Whether it will be in a refinery subject to EIA, whether it will be in a refinery subject to some other system, or where it will be in a refinery where there is no such control. And this comes back essentially to the court's point about what was the point of climate as an impact being included as one of those factors in EIA in the first place, if this type of downstream emission was not going to be considered to be an indirect effect in relation to climate. What is climate doing, if not capturing or applying itself to these sorts of indirect effects? This is not climate exceptionalism, by the way. This is understanding the nature of the climate factor in order to understand the interpretation of indirect effects within the directive and the regulations.
But I think Mr. Moore's answer to that was that it's perfectly possible to give sense to the references to greenhouse gases and climate change within the scope of his submission as well, because there will be projects which are directly having an impact on greenhouse gas emissions, the thermal power plant and so on.
Yes, exactly, my lord.
Right.
That is the big problem, because the EIA regime relies on both direct and indirect effects being assessed. That is the whole point. And I literally don't understand how the Secretary of State can make the submission that the purpose of the EIA directive is a justification for the approach that he suggests this court should take.
Can I ask you this as well? One thing that bothers me a bit about this case is that there is no European judgment which accepts the width of the submission that you're now making to us. I mean, the 2014 directive was the one that introduced the amplified references to climate change, and it's been pointed out that, in fact, reference to climate has been there since 1985.
I need to address that, my lord.
Yes, I mean, so why hasn't there been any suggestion, so far as I can see, but tell me if I'm wrong, in any of the European authorities that these sorts of greenhouse gas downstream emissions are things that do have to be taken into account in an EIA?
Well, the short answer to that, and then I do need to go to what the 2014 amendment actually did. The short answer to that is that cases arise when they arise, and this is the first case in which it has arisen in this way. This court, in this jurisdiction, has the privilege of dealing with that question. It just has not arisen in the same way. But we do say that there is helpful jurisprudence from the CJEU, which as a matter of common law interpretation is relevant to this court's analysis, and that is Abraham. Because Abraham dealt with operational development and indirect effects and what they mean. And what we ask this court to do is apply that reasoning to minerals projects and their indirect effects. But let me turn, please, to the 2014 directive, because Mr. Elvin ran through what he said the amendments were, but he omitted to mention the key change. And the court can see this at 1255 in the bundle, looking first at the directive as amended. At 1255 in the bundle, you see there Annex 4, paragraph 5F. So it's actually on 1256. But 1255 is what the description of the likely significant effects is, and 1256 is this paragraph: the impact of the project on climate, for example, the nature and magnitude of greenhouse gas emissions, and the vulnerability of the project to climate change. Now, Mr. Elvin mentioned that this latter part, the vulnerability of the project to climate change, was new in relation to the 2014 directive. What is also new, and what he should have alighted upon, is the first bit.
So the whole of 5F?
5F is new, and the key words, for example, the nature and magnitude of greenhouse gas emissions. The directive never previously mentioned the nature and magnitude of greenhouse gas emissions. That is new.
The whole of F is new, is it?
The whole of F is new.
Yes.
The reference to the word climate was in another part,
Yeah.
and he made that point. But the whole of F is new. And if the court wishes to see that in relation to the EIA regulations, the old EIA regulations are in the bundle, set out in the Frack-Free Rydale case at 1463. At the very bottom of 1463, we see the cognate part of the old EIA regulations, the cognate to the directive. And what was required at the very bottom of that page was a description of the aspect of the environment likely to be significantly affected, including, etc., climatic factors, full stop.
So does this reflect the unamended form of the, I think it's the 2011 directive?
Correct. And also the next page, my lord.
So climate was there.
Climate was there. Next page down, paragraph 4C, what is required is a description of the likely significant effects of the development. This is the exact same paragraph as the one I just looked at in the new directive, of the amended directive, and all that was mentioned there was the emission of pollutants being required to be described. So what the 2014 directive did was change that paragraph at the top of page 1464 completely and add in 5F with the direct reference to the nature and magnitude of greenhouse gas emissions. And in fact, the upshot of that was that for the first time in this country, guidance was produced on the assessment of the extent and magnitude of greenhouse gas emissions, and that was the IEMA guidance. And the court sees this at page 894 of the bundle, where the IEMA guidance, so that's...
Is that the Local Government Association?
No, that's not.
Oh,
that is a different set of guidance, which is put together by the main professional body, the Institute of Environmental Management. I knew there would be an acronym that I wouldn't be able to remember.
I think it's set out on page 892.
I'm very grateful.
There is a description of IEMA.
Yes. And what IEMA did, and you see this at page 894, paragraph 1.1, was to publish guidance. And if you see the last sentence of paragraph 1.1, the requirement to consider this topic has resulted from the 2014 amendment to the EIA directive. The left-hand column. Sorry, I should have said that. So it is not right that simply because climate was previously mentioned in the directive and the regulations, that the assessment of the extent and magnitude of greenhouse gas emissions was something that was regularly undertaken. It wasn't. That was what was brought into stark relief by the amendment in 2014. That is why the directive explicitly in its recitals referred to the changes being required in relation to climate. My lords and my lady, there are 2 points that I must make before my time runs out. The first is in relation to Brussels, and the second is in relation to Blewett. So can I ask this court first, in relation to the Brussels case, to turn up in the call volume 1648. That's the head note, which is upside down. But thankfully, I go there just to show what the question was that was being asked.
This software lets us rotate it around, so...
Does it?
Yes.
Right-hand.
I mean, I could say that the Secretary of State, in his analysis, turns this case on its head. So the question that was being asked in question 1 is whether the development, the project, fell within paragraph 7A of Annex 1 because of the understanding of the term, quote-unquote, construction. So the court was being asked to understand or to interpret the word construction. What must be guarded against at every point in relation to the Secretary of State's submissions is that the analysis of what the term construction means was being applied to what the term indirect effect means. And that is wholly wrong. The Brussels case does not say anything about what the term indirect effect means. It is a misreading of Brussels to suggest that indirect effect means the physical works. And it is a misreading of Brussels to then apply a suggestion that the project is the physical works, or the indirect is the physical works, to support the Secretary of State submissions. The second and important point to make about Brussels is that as an analysis of the wording of the directive, what the Advocate General and the CJEU did was interpret what the word construction means, and then that was, as a matter of law, the extent of the word. And if I can just give the references to that. So what we say is that is akin to the statutory interpretation analysis that the appellant says is correct in this case. The references are CV 1655, AG 26, and CV 1662 in the court, paragraph 26, where they held that the term construction was not in any way ambiguous and must be understood as having its normal meaning. And in my submission, that goes very directly to the Secretary of State's criticism in this case that in some way there is a very broad or very wide or unprincipled analysis being applied to the term indirect effects. In fact, the only principled analysis of statutory construction is the one that is undertaken by the appellant, because we look at what the plain meaning of the term is, and that does not need a gloss. That is not an open-ended approach or an unprincipled approach. It reflects the deliberate choice of the wording in the directive in light of its purpose. And this is an important point, I think, to make. The fact that a word as a matter of language has a wide meaning does not mean that it is necessarily imprecise. So the fact that the term indirect effects has a broad purview and brings many effects into what is an indirect effect does not mean that it is an elastic term and an imprecise term.
So do you then support effectively a but-for interpretation of that term?
An indirect effect is not a direct effect as a matter of language. That's what it means. And there is a prior question, is something an effect at all? And the answer to that question will have a measure of causation. And it is right to ask, in answering, is this an effect of the project?
I'm so sorry to interrupt. When you say will have a measure of causation, does that mean you're not contending for a but-for linkage?
The end of my sentence was to be, it's right to take into account when understanding whether something is an effect or not, whether it would arise if the project never occurred. And that is right because of the purpose of the directive. The purpose of the directive is to apply the preventative principle, the prevention principle. Greenpeace is right about that. There's a reference in Greenpeace's case. to give a decision maker the opportunity, before consent is given to a project and something happens that can't be taken back, to consider the likely significant environmental impacts, both direct and indirect, that would flow. And in a circumstance like this, and this is all the court is being asked by the appellant to do, and I think I should stress that, in the circumstance of fossil fuel development for commercial production, where there is an indirect effect through the combustion of greenhouse gas emissions, this court is being asked to decide as a matter of law that that is an indirect effect. That is no lengthening or broadening of the term indirect effect impermissibly. While I'm here, I just need to say something more about two words that Mr. Elvin alighted on and the gatekeeper point, and then I do need to take the court briefly to Blewett. My learned friend Mr. Elvin, when he was talking about likely and significant as gatekeeper words, he said that that's about what goes into the environmental statement. It's just an entry point, and it doesn't say anything about what happens when EIA is done. And in my submission, that is entirely incorrect. And it is crucial at the EIA stage as well, whether an effect is likely and whether an effect is significant. And indeed, one sees this in the Kilkenny case itself. Because, as I mentioned earlier, the upstream impacts of the cheese factory were assessed as indirect effects in the EIA, but what was decided...
On the environmental statement.
Yes, sorry, in the environmental statement. The EIAR in Irish terms. But what was decided was that they are not likely or significant indirect effects, essentially because of mitigation and because of the economic functioning of the market. And one sees this at CV 1739 at paragraph 68 and a bit later on at paragraph 70. It was accepted that they were indirect effects and it was assessed, but then what was decided was that they were not likely or significant. And that is commonplace, and the court will recall that the appellant relied on the fact that it's commonplace that an effect is scoped into EIA simply for it to be shown not in the end to be likely or significant because of mitigation or because of some other factor. That is very often.
So you would say that questions about whether this is just going to be, if it didn't happen, it would be substituted by something else, other milk, other oil. You say that goes to not whether it's an indirect effect, but whether it's likely to be significant.
Yes, so whether it's likely, first of all, and then whether it's likely to be significant. Finally, my learned friend for the council, and indeed all the respondents, but in particular in her submissions, my learned friend for the council referred to Blewett in her submissions on law and judgment. And I do need to ask the court to go to Blewett at 1371. That's the very start of the judgment by Mr. Justice Sullivan as he was then. And the court will see from paragraph 3 to 7 onwards that what Blewett concerned was reclamation of land from a post-coal mining spoil tip by replacing the spoil essentially with landfill. It was accepted to be Schedule 2 development. and it was accepted that there would be direct and indirect impacts on groundwater and human health. And the court will see that at 1372. What was at issue in Blewett was not whether these human health impacts were indirect effects, but whether how they were assessed and the extent of the information that was included, including in relation to mitigation, was adequate. The court sees this at paragraph 13 on 1371. So Blewett, and there I make 3 points about.
Sorry, 1371.
What?
I'm not sure that page reference.
Paragraph no, that can't be right.
1373.
1373.
Yes, I
yes,
see.
1373, I apologise. Paragraph 13, 1373, the court sees the questions that were put by the claimant. And at 1378, at paragraph 31, the court will see that the environmental statement, one over the page as well, from 78 to 79, the court will see that the environmental statement included an assessment of the impact on groundwater and human health. So 3 points to be made. First, Blewett was about the extent of information reasonably required for reaching a reasoned conclusion on significant effects. It was a Regulation 18.3 question. It was a gatekeeper question. It was not about the meaning of indirect effect. Second, the only broad statement that Mr. Justice Sullivan, as he then was, makes about the interpretation of the regulations is at paragraph 41 on 1381, about 4 lines down from the top. And he says the regulations should be interpreted as a whole and in a common sense way. And the appellant could not agree more or rely more firmly on that. The only common sense interpretation before the court is that urged by the appellant. And third, Blewett is another example of where an indirect effect was assessed, both on health and on groundwater, but in the end was found not to be likely or significant. So nothing that is said by the appellant is against Blewett, and the approach to interpretation supports the appellant's case. I'm mindful of the time. I do have one last point, but I do need, and that's why I checked, to make another short point before I finish. So there's 2 points left. The Secretary of State submissions before the court today have evolved the Secretary of State's case somewhat from what is seen in the written case. The Secretary of State's position before this court, up until my own friend Mr. Moore's oral submissions, was that it is not a question of law whether something is or isn't an indirect effect. It was a matter of evaluative judgment. And that morphed somewhat in my learned friend Mr. Moore's submissions into the Secretary of State essentially urging on the court the adoption of parts of Mr. Justice Holgate's analysis when that was never previously the case. And the reference for that is CV 223, paragraph 31. in the Secretary of State's written case.
This sometimes happens in this court.
Indeed.
Questions are put and...
Indeed. But it is... Indeed. In my submission, though, it does go to the force of the case that is made, that by deliberate choice, the Secretary of State's approach, all the way up until oral submissions, was to support the Court of Appeal's evaluative judgment approach.
Either that was right or wrong. That's what we have to decide.
The upshot of that, though, and the reason that I take the court to that point, and it's a point that's made importantly in our written submissions, is that the approach taken by Mr. Justice Holgate is not really the kind of benign other side of the coin from the approach that's taken by the Court of Appeal. So it's not the case that the approach taken by Mr. Justice Holgate solves the difficulties that are raised by the Secretary of State in relation to concerns, for example, around legal uncertainty. As the OEP points out in its submissions, in fact, it would simply give rise. The test that's suggested by Mr. Justice Holgate is not a test, and there would simply be more uncertainty in reversion to that approach.
Well, we can certainly look back at the OEP submissions with that observation in mind.
My Lord, I'm grateful. Yes, so for your note, that's in our submissions at paragraph 169, CV 142 as well. My Lords, I'm conscious that I didn't address at all what I said I would at the outset about climate policy and that fine distinction about climate policy in general being a material consideration, but the extent of greenhouse gas emissions not being a material consideration. And if I can just give your Lordships a reference so that your Lordships can see that what the national policy is in relation to climate, in fact, gives the lie to that analysis. The reference is, in fact, unfortunately not in where the court has the national planning policy framework.
Have you got the page and we can make a note of it?
Yes, it's CV 429, paragraph 57 of Mr. Justice Holgate's judgment. It quotes verbatim what the national planning policy framework says, although it's not in quotes, because it quotes it verbatim. And it says that the planning system should support the transition to a low-carbon future in a changing climate. It should help to shape places in ways that contribute to radical reductions in greenhouse gas emissions. The policy test in the NPPF asks the decision maker to look at whether the proposal or the project will contribute to radical reductions in greenhouse gas emissions. Inevitably, we say that means that the extent of greenhouse gas emissions is a material planning consideration. So to conclude, the appellant submits that there is no practical or rational impediment to assessing downstream emissions of fossil fuel development. The public will wonder why this is not already happening, given that the point of fossil fuel production is for it to be burned, and in light of the climate crisis that we face. This court can clarify the position and ensure that EIA is applied in a consistent and predictable way by finding that downstream greenhouse gas emissions are, as a matter of law, indirect effects of fossil fuel development. That falls within EIA, and or, if the court sees fit in relation to the OEP's submissions, to make appropriate further guidance.
Any other questions? Yeah. Thank you very much.
Very
indeed.
grateful.
You have all given us a great deal to think about. We will consider all of those submissions. We'll review all the written submissions again and the materials you've referred us to. And we will, in the usual way, let you have our judgment as soon as we can. Thank you all very much.